You use marijuana all day, every day.
Not really day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tenike.
Morning.
Are we waiting on anybody?
No.
Okay, what can I do to help you all today?
Yes, sir.
Get us off of your docket is what you could do. Go ahead, Lacey. Start talking.
That's pretty specific. Ms. Kimball?
Yes, sir.
Specific.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for screening and a motion for a psychological exam based upon that custody evaluation recommendations.
Blah, blah, blah.
You'll have an opportunity to respond in just a minute.
I need to pause the hearing. I don't have an attorney. Can you give me some time to get an attorney? I haven't had adequate time to obtain an attorney, and my attorney withdrew, and I'm going to need one appointed by the state.
That's not an option. There's nothing there unless someone's asking that someone be held in contempt and jailed, which is not something that's set in front of me, or it's a action by the state to terminate a parent's rights or something like that. Those are the only times I have the ability to appoint an attorney for you.
Okay, then go ahead.
We also had sent discovery out as laid out in our motion sometime back. I had worked with Ms. Stiles' prior counsel and had agreed to 2 extensions, and then we ultimately never got a response, and she filed a motion for protection.
She got plenty of responses. Objection.
What's your objection? Hold on, wait a second. Ms. Stiles, you just need to object and then let me know what your objection is. Don't yell at her.
Objection to hearsay. How do I submit my documents to you directly?
Hold on. So, Ms. Kimball, are you saying this was something that happened between counsel?
Yes, back in November. We are now setting this hearing is for our motion.
She also represents Cody and also fucking sit there.
Okay. So, Ms. Stiles, I'll unmute you in just a second. You need to let Ms. Kimball finish what she's saying, and then when you're talking, she'll let you say what you're saying, unless one of you has an objection that is a legal objection. You can't just talk at the other side. So, Ms. Kimball, why don't you just go ahead and finish telling me what? So you said that you're wanting a drug screen, so a drug test, and do you say psychological or psychiatric? I thought you said
psychological exam. And then we have an order to compel Ms. Stiles to turn over the responses to our discovery request, to provide dates for a deposition, and for attorney's fees for $1,500.
All right. So, Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond. What is your response to those things? Let's go with the screening part. Do you have an objection to taking it?
I'm not going to pay for it because I'll tell you up front I'll file for marijuana.
When was the last time?
But I'm happy to take it on.
When was the last time you took marijuana?
I use marijuana daily. Okay.
What is your response to the request for a psychological evaluation?
I'm not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. I'm asking your position.
That's my response to you.
Okay.
You will not get any. I'm not doing a psych eval, and you cannot make it mandatory.
Interesting. In terms of the motion to compel, where they're talking about discovery, what's your response to their motion to compel?
Have you read their discovery? When are you going to view my videos?
Ma'am, you need to answer my question.
I answered your question.
All right. So I'm going to warn you that it is completely inappropriate to swear like that in court. You need to take yourself, you need to put yourself back on camera. Thank you. I'm not going to allow that. So if you do that again, I'm going to sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it. You can answer the question and be respectful to Ms. Kimball and to the court. And I'm not going to tell you how to answer, but you can just say whether or not you're in agreement with something. In terms of the motion to compel, I haven't heard it yet. So I'm just trying to find out from a cursory standpoint what your position is on these 4 issues so that I can figure out if there are partial agreements or not. It sounds like there aren't. So based upon your response, I'm going to take it that you're not in agreement with their motion to compel. In terms of their request for deposition dates, what's your response to that? I sent you a prompt to unmute yourself.
What dates?
Ms. Kimball, do you have proposed dates?
I can. I would propose.
And whose expense? Mine? Because if it's mine, I'm not doing it. Sanction, give me $100 fee. Woo,
Okay,
woo.
well, so I am finding you in direct contempt.
Okay, 1 fine.
Finding you $100.
Okay, make it 2. I said 2 words.
Ma'am, I don't think you want to do this. At least the people in the courtroom seem to think you don't want to do this. I will, not because you're requesting it, but because you're not following the order. As I said, sanction you.
Please do.
Let me do it. So that's
Please.
$200.
Here, I'm sure she wants my apartment number, right? Turn it to Miss Kimball. You're going to want.
Stop. That's not something that she asked for. Ms. Kimball, what dates?
No,
what
then
dates are you
everybody
requesting?
else.
I would propose August 30th or September 2nd.
Okay.
How long?
Are you wanting how long? That's a valid question. Is it half day, an hour, 2 hours? What do you
I
anticipate?
would anticipate a full day.
Okay.
So what, the
Ms.
30th or the 2nd?
Which of those dates works better for you, Ms. Stiles?
What time, dumbass? 3 contempts.
You're correct. That is 3.
Yep.
Supposed to start at 9 a.m.
What date?
Stiles, that question is to you. Never
I
mind.
said what
I'm not gonna-
time?
I'm not gonna let you
Time,
pick.
date? You know, these
I'm not
things.
gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that as another violation. So, in terms of the request for the deposition, she didn't have any objection. I'm going to note for my own record that she opted out after flipping me off. I won't comment. So I'm going to grant the request for August the 30th at 9 a.m. in your office. Miss Kimball, sorry. You can just put as much specificity as appropriate for in order that it would normally have your address and time and everything like that, but just so there's no confusion since she disappeared, I will sign an order that orders that the deposition take place. Let me go back since she left and I heard her responses. I was going to take testimony from your client and from her. Do you need any testimony from your client about the drug screening? So I haven't read the custody evaluation, but if they're requesting it, your client's asking for it, she's whether she's going to pass or fail is not the determinative factor, because you may want it to see if there's something other than marijuana. So I'm going to grant that request I don't need testimony from a client about that. In terms of the psychological evaluation, I'm just going to allow your argument.
Your Honor, I think based on the presentation today of Ms. Stiles and the custody evaluation report from Mr. Bouchard, I think it's apparent that there could be some mental health issues that would obviously impact custody and access to the child. So we believe a psychological evaluation would be necessary. Furthermore, Ms. Stiles is not in possession of any of her children at this point and has not been paying support on AILA for a little over a year now. And so we would be requesting, she's also received the tax stimulus funds and income tax returns for claiming the children. So we would ask that the expenses be put on Ms. Stiles to pay for that.
I'm sorry, to pay for what part specifically?
For the drug test and the psychological evaluation.
Because she's been receiving that money.
Yes, sir.
Okay. I think I know the answer, but I don't want to assume. Mr. Parnell, have you received any of that money? Does she provide even $100 to you?
No, sir.
Thanks. I was taking your attorney's representation as being true. But sometimes it helps me just to understand. Okay, in the motion to compel, did she provide any response? She had an attorney as recently as last month.
There were
recently as the last 3 weeks, but it's been a couple days.
there were some, I've allowed 2 extensions by agreement, Rule 11 agreement. The responses we got were some partially answered interrogatories, but they weren't unsigned. But for the interrogatories, the documents, everything was just kind of blanket objected to. For, I believe it's for harassment was the objection. So, and we received no documents at all. Ms. Bertrand did represent that there could be some documents in her office, but that was when she was still on the case.
And were there objections made to the interrogatories?
Yes, sir. Objections to undue burden, unnecessary expense, harassment, or annoyance.
Okay, let me pull them up. Okay, so in reviewing them, one is about persons expected to testify at trial, identity and location of employers in the last 2 years, identity of people she's had an intimate relationship with for a relatively 5-year period. Mental health and physical health care providers or objections, but then that was actually answered, but just names, not any address or phone numbers or anything like that. Income questions not answered. Monthly living expenses, says litigation, auto payment, cell phone. Did you get anything Did you get any numbers, or is that all you got?
That's all we got.
Okay, she objected to why the prior order should not be modified. She objected to a question about the child's present living environment and visitation for the temporary orders, if that's not in the best interest, state why generally. She objected to that. She provided a partial answer. She objected to child support questions. She objected to counseling and psychiatric questions. That's one I haven't seen before. Please explain in detail how you perceive that the following people treat you without respect. It's an interesting question. Are Kathy and Mike the paternal grandparents?
Yes, sir.
And the last one is about if she's seen any changes in the demeanor behavior of the child immediately before or after the child's been in possession of the father. So any objection to relevance, all of those are relevant. The objections to there being undue burden, unnecessary expense. I'm overruling those. It's not an undue burden to answer 12 interrogatories. It is not an unnecessary expense to respond. And I'm overruling the objections to harassment or annoyance. So I'm overruling all those objections. And I will, if you put in the order, I'm going to order that she provide full and complete answers to all 12 of those interrogatories, and that the objections are waived. And then in terms of the request for production, so it says that there's an objection in time and place, and that the document that she'll produce requested documents at O'Neill Wysocki PC at their address upon reasonable notice. So did you and Ms. Bertrand have a conversation about that?
Yes, I tried to have a conversation about that, and it was not well received. And she also pointed to the fact that she had filed a protective order as well. And so she did not want to deliver any documents or allow me to inspect until the protective order was heard.
Mr. Parnell?
Yes, sir. Sorry, my phone's blowing up. She's texting in group text again. This happens quite frequently with her.
It's fine.
Apologize.
I was going to ask if she was participating by text. If you can just put your phone on mute, please, that will help me because I'm trying to review your terms of motion. Thank you.
You see if there's something I can do on my phone as well. Sorry.
Well, it may be muted. It may just be vibrating. I don't know.
Yes, sir. I've turned it back on silent mode. I'm so sorry.
Thanks. It's fine. So September 29th, the request for production was sent. Response was provided November 20th. Okay, there's the part about the agreements to extend. There's a mention of respondent refusing to comply with the child custody evaluator. Since I'm not taking testimony from your client right now, are you wanting that to be admitted?
She ultimately finished the child custody evaluation and did comply.
Okay, so I'm just trying to clarify. I'm not trying to get a yes or no. I'm trying to understand. So you referenced earlier that the request for the drug screening and the request for the psychological evaluation were contained in the custody evaluation.
Yes, sir.
Are you wanting that to be admitted?
Yes, sir. I was going to have Mr. Bouchard there to testify at trial.
Okay, so in terms of your motion to compel, I addressed by granting the request as to the interrogatories. What you put was within 15 days of the order. That's reasonable. As to the request for production, I'm granting that request that she also produce those documents to your office. So anything that she took to her attorney's office, she needs to deliver it to your office now, since she didn't provide any argument of substance. To that request. And since she no longer has that attorney, it's unworkable it doesn't make sense. Her attorney should have and may have returned her documents to her if there were ones there. The request that she be prohibited from further discovery, I'm going to grant at this point. If she complies with fully answering the interrogatories and the request for production within 14 days of this order, 14 days of sorry, it says 15 days. Within 15 days of today, about dates we addressed. So that's August 20th, your office at 9, I'm sorry, August 30th, excuse me, August 30th, 2021 at 9 a.m. in your office. And then you're asking for attorney's fees of $1,500. So I do need some testimony about that. So I'll waive swearing as an officer of the court. What testimony do you want to provide regarding the attorney's fees?
Yes, sir, Your Honor. My name is Lacey Kimball. I'm licensed with the State Bar of Texas. I've been licensed for about 8 years and recently became board certified in family law, effective as of December 31st. I have my hourly rate is at $275, which I believe is fair and reasonable based upon my knowledge of other attorneys and their general billing rate. I've expended approximately 5.5 hours, which is just slightly over $1,500 in preparing the discovery, sending it, the Rule 11 agreements, conversing with trial, following up on the motion for the protective order, the motion to compel, and now this hearing. The hearing, obviously, as of today, all of the drafting was done within a day or two prior to the date of filing or service of discovery. And so at this point, I would request $1,500 be ordered from Ms. Stiles, made payable for attorney's fees incurred in pursuing this discovery.
Thank you. So I'll grant that request for $1,500 in attorney's fees. And I'm going to find that that's reasonable and necessary and appropriate. In terms of the motion for draining, you're asking her to go take a 10-panel nail test, and that she pay 100% of the testing costs. I'm going to grant that as well. If you will include in the order, please, my normal language. I'm not going to write out an associate judge's report. I'm just granting your motions as I'm reciting. It tracks your motions. Like everything I've said so far tracks your motions. But one thing I put in is a failure to take is considered to be a positive test. So if you'll include that in the order so that she's aware of it. I don't know that will necessarily change anything, but it puts everybody on notice that just deciding not to take a test is not the answer. In terms of the request for the psychological evaluation, I'm granting that request. You're requesting that Dr. Lammers do that?
Yes, so that was the recommendation in the custody evaluation.
Okay, so I'm going to grant the motion for psychological evaluation and grant the second paragraph where it asks that the respondent, which is the mother, Ms. Stiles, pay for her psychological evaluation. It's not fair to Mr. Parnell to pay for the evaluation that's it's based upon her whatever happened in the custody evaluation, whatever prompted that. Based upon my experience with the case, it's not fair to Mr. Parnell to have to pay those costs. So I'm granting that completely as well. Okay, so psychological evaluation, motion to compel, deposition, and attorney's fees. Those are the 5 things that I heard you say at the beginning, and those are the things that I have in the file. Was there anything else?
No, sir.
All right. If you will send a copy of those orders to me once they're done, I will sign them. Just send them as PDFs.
Oh.
And I'll sign them and send them back to you. You don't need to do a 10-day letter or send them to Ms. Stiles prior to submitting them to me. You can just send them, just CC her so that it's going to her. And then assuming that it tracks the language of your motion, which I'm sure it will, or I have every confidence that it will, I will sign them and then I'll just reply all. And Mr. Parnell, so you're aware, from time to time, increasingly, litigants will take it upon themselves to email me. Although I send them a response that says I can't consider ex parte communication. Sometimes that stops people and other times it doesn't. I want you, and if the mother was here, I want her to know too, that I don't consider those communications. That's not directed specifically at her. I'm saying it because of what was going on a few minutes ago, but just so that you understand, I only consider things that are here in court. So your attorney is professional. She would never do this, but whether it's an attorney or a litigant, I don't consider those things. First of all, it's a rule not to, but second, it doesn't make sense in our world to do that. We just consider evidence and testimony that's in court. To the one thing that she was asking that I might have been able to address if she'd stayed, the answer is if she wants to provide documents or evidence, she does that the exact same way her attorney did or your attorney does by pre-submitting them and then offering them and staying. That's how. So Mr. Parnell, the point of that is just if your phone is getting, as you said, blown up by text messages from her, if she were to send me ex parte communications, just like any other case, I'm not going to consider them. I'm not going to read them. I will look at an email to see if it's something that's requesting a special setting, but that's as far as those things go. So you know, if you get ex parte communication that's directed to the court, I'm not going to address it. I'm just not going to look at it. So you don't need to respond to those things. Anything that needs to be addressed, we'll address in the hearing. And obviously, any request for a special setting would be something that I would have you all coordinate your calendars on. Okay, I'm going to go ahead and excuse you all at this point. I wish you all the best.
Thank you, Judge.
Share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.